Yeah, good morning and a very warm welcome from Irina and myself to the Taylor Wessing Coffee Break Life Sciences Startup session today. My name is Stefanie Greifeneder. I'm a partner in the Life Science Regulatory team in the Munich office of Taylor Wessing, and I'm joined by my wonderful colleague Irina Rebin. Today's session is session number 4 in the Coffee Break Life Sciences Startups. We today look at research and development collaborations, short-term R&D collaborations. Here we have identified the following hot topics, which we would like to present to you in the next 30 minutes. First, there is the question, why are R&D collaborations so important? We look at different setups for R&D collaborations. We have identified the 5 most important tips and tricks for R&D collaboration agreements, and also look into further important contractual clauses. And then at the end, we have a wrap up, and we would also be very pleased to be able to answer some of your questions. You will find the question section in the right hand of your screen, and please feel free to drop all your questions which come up during the session, and we are happy to answer them all together in the end. So let's go into the details. First, there is the question, why are R&D collaborations so important for startup companies? I think here we have a quite special situation that startups normally in the beginning of their life cycle do not have a lot of employees and do not have very big R&D departments, but they start with some people, and so it's natural that R&D support is needed from third parties. This can be academic institutions, especially if there is already a collaboration, for example, to university hospitals where the startup has been founded first and spin off from the university, or it's also a possibility to cooperate with other life sciences companies or service providers. And the R&D collaboration, or the aim of the R&D collaboration is to gather new knowledge and new IP, and therefore the IP sections of an R&D collaboration agreement are the core stipulations in such document. There you have to look which know-how and IP has been generated under the R&D collaboration, and you must ensure that you have access to all of these IP rights and know-how in a sufficient manner for yourself. We will look into this later. First, before you start to negotiate R&D collaborations, you should look at some general questions to structure the collaboration correctly. There are 2 different types of R&D collaborations. First is fee for services, and the other is a real collaboration where both parties render R&D services. Fee for services is also named contract research. This means that you simply source out some of the R&D questions you have to a academic institution or a life science service provider, and they will do the research as described in the agreement, and you get the results against a payment from your side. So this is quite straightforward because you pay for something what you get. Where the IP allocation is often a little bit more challenging and difficult are the real collaborations where really both parties participate in the R&D collaboration, so that in the end the new know-how and IP is developed by participation of both parties, and here is the question how such IP is allocated. Irina will look into this in a few minutes. So first question is it more or less an outsourcing situation, and then you have this fee for services framework, or it's a collaboration where both parties work together, then it's a so-called real collaboration. And then you have two different possibilities to structure the agreement. First, if you think that there will be different projects and it will be a longer lasting relationship, then it makes sense to negotiate a framework agreement where all the general terms and conditions of the R&D collaboration are covered. And then the different projects are concluded via work orders, so that you include very specific detailed description of the project in the work order, and then the work order becomes an integral part of the framework agreement, which means that all general terms which you have negotiated in the beginning are also apply to the work order. So in the framework agreement, for example, the general IP allocation would already be concluded, and then you don't need to negotiate that for each work order. Or you say, we have a very specific task, which is probably a one-time assignment to a third party, and then you can go for a single agreement without doing the framework agreement work. Before you start the R&D collaboration, you should always have a look if you have a CDA or NDA, confidentiality disclosure agreement or non-disclosure agreement in place, because often before you start the R&D collaboration, you have to discuss with the other party certain confidential tasks, and in such case it's always important to have a CDA in place, and if you have one, you should look into it, and especially at the term of the CDA, because often CDAs or the disclosure period in CDAs is quite limited, so you probably only have a disclosure period for 1 year, and if you're already discussing the project with the other party for 9 months, you only would have 3 further months where the confidential information which you share is protected under the CDA, and therefore sometimes it's necessary to include a comprehensive set of confidential information regulations also in the R&D collaboration agreement, even you already have a CDA in place. So that's a case-by-case assessment, and you always should have a look at this. In some bigger R&D collaborations, it's also useful and often happens that the parties first negotiate a term sheet where the commercial terms and the project is generally described, and this makes, for example, sense if you are not 100% sure if the R&D collaboration with the other party will work out in the end, and here you can get a sense if it's working from a general perspective and from a commercial perspective, and enter into a term sheet first. This is a much smaller document with no legal technical language, and then once you have agreed on these general terms, you can go into the more detailed negotiations of the framework agreement or the standalone R&D collaboration agreement. If you plan to do more R&D collaborations, it might also be a good idea to prepare a template, probably one for the fee for services situation and one for the real collaboration, so that you are able to have a document which you can provide to your potential contractual parties and start the negotiations from there. Other possibility is that you ask your collaboration partner if they have a document in place. It's always the question which way is the more efficient one. That really depends. Sometimes it's easier really to start with your own template, particularly if you have specific needs which should be addressed from the very beginning. But it also makes sense to await the draft of the other party and look into that. So I would say in R&D collaborations there is no quite advantage or big advantage of one or the other option. Now we have identified 5 most important tips and tricks. There are 3 topics which correlate to each other. These are the description of work packages, deliverables and milestones, and then the core of the R&D collaboration, the background IP and the foreground IP. If we look at the work packages, this is very important to have a detailed description of the work which shall be done under the project plan, because that's the definition of the project in writing. And in each case, if something doesn't go along the plan, or if you think that your partner is not doing what he should do, you always need to look at the description of the work packages, and often you have that the work packages are described in a way which is too general, and then it's difficult to say to the other party that there is a deficiency from the work package and they need to work along it. So it's very important to have a detailed description. And linked to that is the question of deliverables, because it's also very important to have a clear definition of deliverables. This means that at the end of each work package there should be a result, and then you need to decide how the result shall be presented and handed over to you. Should it be a report, or do you also need the material or the whole set of raw data? So here you need really to think about what is needed from your side, and again describe it very clearly in the document. And this can be made in the project plan, in the work packages. So for example, you start with describing each work package, and then in the end it says the deliverable for each work package is X, Y, Z. And if it's a big collaboration agreement which takes quite a long time and the research plan might cover some years, then it might also be a good idea to include milestones, because then it's easier to look at the development of the project, and if everything is in plan. And it's also good to have the milestones, because you can link the payment obligations to the different milestones. This means that the question always is, when do you have to pay for the services? And here, normally, you have an upfront payment, which is due at the beginning of the with signing of the agreement, and then you should only pay in a point of time when you already have received some deliverables or milestones, or the final results. This is also important, because the payment is the most important issue you can bring against your contract party if it's not working properly, because then you can say, we only pay once you have done your work properly, and so you can put some pressure on them when there is an issue with the timetable. In bigger projects, it might also be a good idea to think of establishing a joint steering committee. This means that if there is a delay in the project, or something might be, if there might be a necessity to amend the project, this can be discussed in the steering committee, and the steering committee then has clear rules how they come to a conclusion. And should they not be able to come to a conclusion, you can include an escalation effect, for example, that the issue needs to be discussed on the C-level first, and to find a solution. And this often helps, and you really get to a solution, and therefore establishment of a joint steering committee is a good idea. And now I hand over to Irina for the background and foreground IP, which is the very, very important topic.
Thank you, Stefanie. Yes, I agree. The heart of every research and development agreement are the provisions on IP, in particular provisions on who should be entitled to new IP, the so-called foreground IP, and thus also inventions. But first, let's start with the question, what is background IP? Background IP refers to the so-called already existing intellectual property of the respective parties, like patents, know-how, information, data. These are rights that were developed by each party independently and before the start of the cooperation, and are now to be incorporated into or to be contributed to the cooperation. So it is recommendable to clarify here that the background IP contributed in each case should remain the property of the respective party. Then another important aspect is, after the end of a project, you as the commissioning company might have an interest in the commercialization of working results, the resulting intellectual property and the associated know-how. And under certain circumstances, it may be necessary to obtain a license to the background IP of your collaboration partner. So you should therefore ask yourself the question before concluding the research and development agreement: do I need the background IP of my contractual partner in order to be able to make full use of the results and of the collaboration after the end of the project? So discuss this with your collaboration partner before signing the R&D agreement in order to avoid amendments to the R&D agreement post-execution, or to avoid entering into a separate agreement, a so-called license agreement. So the other IP section, which is of crucial importance, is are the provisions of foreground IP. The focus of every research and development agreement is therefore the question of the allocation of rights to the inventions made in connection with the research collaboration. This is where it is determined what the parties receive as a result of their collaboration, well, besides the payments and the budget and so on. In practice, this point is one of the most controversial in R&D contract negotiation. In the context of fee for services or so-called contract research, it is generally the case that the company that commissioned the research is entitled to all results, to all the outcome discoveries and inventions. And an arrangement that occurs quite frequently in practice is that your research partner, the university or the research company, has the right to use and can use new inventions that are of a more general nature and have no exclusive or direct relation and connection to your project plan, or the objectives of the study. In this case, the arrangement or the provisions on IP which the cooperation partner or the university should be entitled to must clearly specify which inventions the university should be entitled to in each individual case, in order to avoid any overlap with your own foreground IP and your own inventions. So in equal, or let's call it conventional research collaboration, the foreground IP is usually allocated between the parties according to their respective intellectual, financial, or actual contribution, and taking into account their overriding future business interests. So the foreground IP can be divided to foreground IP of the startup and the foreground IP of your research collaboration partner, specified to specific fields. So the foreground IP in this field shall be shall be entitled to divided into several fields, but there are also options to agree on joint foreground IP, which we do not recommend because it is quite hard to determine in the end which party has which shares into such joint foreground IP. But if this is something you can't avoid to agree on in a research and development collaboration, we always recommend, and this is what we stated as a general rule, document throughout this whole collaboration what was contributed by which party, especially by collecting all emails, all chat correspondence, all meeting minutes, and all presented papers and slides, in order to then determine each party's contribution to the joint foreground IP. So, with regard to inventions in Germany, many special aspects of the so-called German Employee Inventions Act must be observed. In German, it's the Arbeitnehmererfindungsgesetz, which either you yourself must comply with because you're established in Germany, or your cooperation partner must comply with if its employees are employed in Germany. So the provisions of the German Employee Inventions Act aim to ensure, just general information ahead, that German employees receive a reasonable participation in inventions which they make in the course of their employment, if their employer, so the university or your research partner established in Germany, exploits the so-called service invention in a commercial manner. So these service inventions or employee inventions are called Diensterfindungen in German. The German employee then has the right to an appropriate contribution to the exploitation of the so-called service or employee inventions. And for service inventions made by an employee at a German university, there are specific rules. So to German universities, Section 42 of the German Employee Inventions Act applies, and this section provides that in the event of a exploitation of a service invention by a university employer, the amount of the remuneration shall be 30% of the income generated by the exploitation. So just keep in mind, if your collaboration partner is a German company, the employer has the right to an appropriate contribution, and if your contracting partner is the German university, then the university researcher has the right, the amount of remuneration shall be 30% of the income generated through the exploitation of the university. So please note that if the university or the German company, your contracting partner, transfers the right to a service invention to a third party like your startup, the university's obligation to compensate the employee inventors stays with the university and your collaboration partner. It's not your obligation to pay their employees. So the employer, the German university, the German contracting party has to pay the employees reasonable compensation for the transfer of rights to the service invention. Your company does not have to pay the employee inventors, however, and this is crucial, it is usually the case that your German contractual partner will negotiate or will insist to negotiate a provision in the R&D agreement which aims to ensure that separate remuneration is paid to the university, to your research partner, in the event of a transfer of so-called employee or service inventions. If your cooperation partner is legally obliged to remunerate its own employees according to the statutory provisions of the German Employee Inventions Act, they do not want to bear these costs on their own, as they must contractually, according to the R&D agreement, transfer the invention to you and cannot use it themselves. It is therefore important to determine whether such remuneration for service inventions is already should already be covered in the R&D agreement, which we absolutely recommend to agree on such remuneration ahead, or if it should be reserved for a separate agreement in case there will be a transfer of service inventions, then the party can negotiate a separate agreement on the remuneration to be paid. In case of, let's call it, equal research collaboration, in which both contracting parties are located in Germany and are therefore both subject to the statutory provisions of the German Employee Inventions Act, it can also be agreed that each party bears the costs of remuneration for service inventions itself. This always must be assessed on a case-by-case basis. So there's one last point I wanted to discuss with you with regard to the German Employee Inventions Act. It's Section 42 of the Arbeitnehmererfindungsgesetz, which stipulates that employees of a German university, so again, this provision is limited to the university and not every German company you enter into a contract with. So employees of a German university have the right to decide whether or not to publish the results of their research. The right not to publish research results is referred to as the so-called negative publication right, in German negatives Publikationsrecht. The special aspect of this so-called negative publication right is that the university researcher cannot waive his or her negative publication right in advance vis-à-vis his employer, the university. However, it is common for researchers to waive this right, this negative publication right, towards a third party, like you as a startup and the contractual partner of the university. Therefore, it may be necessary to obtain declarations and agreements from all university researchers involved in the research collaboration. Otherwise, there might be a risk that the researcher will not report all the results to the university, and then the university will not be able to disclose them to you due to a lack of knowledge. So please pay attention to this specific aspect of the German Employee Inventions Act. So when it comes to the disclosure of results and inventions, there are always, we always recommend to agree on provision of, on publication of results as part of an equal research cooperation where both parties contribute services and acts. The parties usually undertake to make all results of the study or the research collaboration available to the respective other party. Both parties have an equal interest in the results of the collaboration. However, it should also be made clear in such publication provisions that all results are subject or shall be governed by the obligation of each party on confidentiality and non-disclosure. So this restricts the parties from sharing data with the public domain and the world. Publication then generally, publication should be agreed on and is generally possible in these cases if the parties have agreed in advance. So in so-called publication clauses, deadlines for the coordination and release of submitted publication are then usually agreed on. The partners then have time to review the submitted publication and, if necessary, take necessary actions and steps like removing confidential information prior to the release of a paper or a slide or a doctoral thesis whatsoever, remove the own confidential information or apply for patents to protect your inventions, and so on. Another aspect, and this brings us to other and further important clauses of research and development agreements, which we wanted to give you a first impression of, is the confidentiality. Stefanie already told you, please have a look at the CDA you've already concluded ahead. Is it still applicable to your research and development agreement from a timely perspective and with regard to the content sometimes? And this is what we always recommend, is to cover the confidentiality and non-disclosure obligations in the R&D agreement itself to be on the safe side. One other aspect is, please discuss the governing law, the place of your jurisdiction, which laws shall be responsible and competent for any disputes arising out of or in connection with the R&D agreement, and do we need an arbitration clause? We always recommend to include an arbitration clause to have the possibility to resolve disputes in camera, which means under the exclusion of the public, because the case may be that company secrets may be involved and you don't want to hear the public participating in a trial of your company or trade secrets. The last two aspects are subcontracting and term and termination. With regard to subcontracting, it might be the case that your contracting partner needs to involve subcontractors in research collaborations if certain projects like the analysis or the manufacturing of samples cannot carry it out by your collaboration partner itself. So in this case, we recommend to only only allows subcontracting if your cooperation partner has notified you that it needs to involve subcontractors and third parties, and you have explicitly agreed on such involvement of subcontractors. This prior agreement gives you an overview of all the parties involved and also allows you to control with which third parties your confidential information, your trade secrets may be shared. So just keep in mind, inclusion only with prior, maybe written consent of your company. Protection of confidential information should be secured, and your contracting partner should be obliged to ensure that the subcontractors comply with confidentiality and non-disclosure obligations in the same manner as the research partner is obliged to under the R&D agreement. And with respect to the liability for subcontractors, the cooperation partner should be liable for any action or omission of its subcontractors as if it was its own breach or non-compliance. And moreover, if there is a chance that subcontractors also make invention, it must also be agreed with the cooperation partner that the cooperation partner claims the inventions made by the subcontractor and transfers them to you. The last aspect, term and termination. The term of the agreement can be defined either by a fixed expiration date or by termination of the investigation, study, the collaboration, and with the provision of all contractual services agreed on in the R&D agreement. So both options are common in practice. Just discuss with your research partner which suits you best. And with regard to termination rights, there must be, we always make a distinction as to whether the R&D agreement is for let's say a fee-for-service, so-called contract research, or a joint and equal research project. In case of contract research, it is common for the contract research organizations grant for termination rights to be limited. So the contract research organization only has the right to terminate the R&D agreement in specific cases like a breach of the agreement by your startup. This is because you as the contracting party usually make large investments, so that the university or your research partner should not be able to withdraw from the contract at any time and without cause for whatsoever reason. And on the other hand, the termination rights for situations in case of for equal research collaborations where both parties have an interest in the collaboration, it is also possible, of course, to agree on mutual termination clauses. Yeah, this is it.
So very quick wrap up at the end. As discussed in the beginning, you should first think about the structure of your intended R&D collaboration, whether it's contract research or real collaboration. Then the heart of the collaboration agreement are the clear definition of background IP and allocation of foreground IP, as described by Irina. Also, very important to think about confidentiality and trade secrets, and from a commercial side, also look at the provisions on payments. That's our wrap up. Sorry for having overrun a little bit, but I think that was worth it. No question has arrived so far. We will send the presentations to all participants afterwards, and if you have any questions, please feel free to contact either Irina or myself, and we are also happy to discuss anything else at a later stage. So thanks very much for taking part, and we look forward to welcoming you again for the 5th session in our series. Have a great day.